Companies Act. A special presentation by The Firm.
I think the last viewpoint that I wanted to bring onto this table is looking at it from the point of view of promoters and thereby converse minority shareholders. And clearly, as all of you have said in your opening comments, the shift in balance of powers has taken place there, because minority shareholders have been empowered in many instances by this act to make their voice heard, whether it is the approval of related party transactions or asking for exits in the case of a change in objects and clauses, etc. How would you look at how that relationship has changed? And let me put a question to you that I know you've been putting to many of your clients and associates. Is minority the new majority today?
On some of the things, yes, it is, because the decision-making authority on certain things has now moved to the minority. But actually, on a broader note, I see a certain element of legislative and regulatory schizophrenia here. The reason I say this is that on a number of things, you're telling the promoter or the controlling shareholder that particularly when you list and you go to the public markets, that you are now like every other shareholder. You have no special privileges. You will not take control premium, you will not do that. So you are, at least as far as your rights are concerned, you are like everybody else, you are a citizen with equal rights. But then when you sort of come into a regime like this and you take out this constituency, namely the promoter or the controlling shareholder, say no, but apart from being equal as far as your rights are concerned, here is a long list of additional roles, responsibilities and liabilities that you have. So I don't think that equation is completely fair. So for instance, in terms of responsibility, say in minority exits, so put options on them, or the kind of additional burdens that I think they will carry has changed the power equation as well. I think it has changed the burden equation as well. I think that's now whether that is justified because of the enormous power that promoters have and therefore sort of like a compensating regulatory feature, one can have that debate, but that is the equation I think that has changed, and that is probably where in the mindsets of a number of promoters who have lived in a very different regime for so long will have to come to terms with this new reality. I think
I have a big smile on my face, sir, because I think the activist in me concedes that some of this may be unviable, difficult to implement and all of that, but it clearly pushes us to a new era of governance, doesn't it?
This is probably the biggest piece.
This is the biggest piece,
This is the biggest piece. It's a fundamental change. There's a paradigm shift.
Yes.
But you know, there's an angle which I'm sure there's no final word has not been said on this, because there may be some majority shareholder who says that now you're putting all the obligations on me, and my basic right, you know, when I buy 51% shares in the company, I have that's my right to property. That's basically right to receive dividend or right to vote. You are taking away my right to vote, and it's a right which is constitutionally guaranteed.
Only in related party transactions.
Yeah, but
only in related party transactions.
But
only if the promoter is involved in that transaction. It's in a very narrow set of cases, and let's admit, those narrow set of cases have been full of abuse in the last so many years. Full of abuse. That had to be halted.
But if I can just sort of add, just from a purist perspective, that fiduciary roles and responsibilities always attached to directors and boards. A shareholder was entitled to act as selfishly as he wanted because of the same theory. That
so how is this putting a fiduciary
you could have dealt with it. It does, because it effectively creates. How do you disenfranchise somebody from voting? Because of a conflict of interest. Why do you say that the majority will not vote? Implicitly because of a conflict of interest.
If a director is the interested party in the board meeting, the director cannot vote. If the promoter is an interested party in a general meeting, the promoter cannot vote as well.
I counsel argue.
We are looking at conflict of interest here, and wherever you are conflicted, you are not allowed to be part of the decision making.
I am not opposed to this view, but I would say fundamentally, as a purist perspective, as Cyril pointed out, there is enough of literature in international legal circles which suggests that shareholders owe no fiduciary duty.
But why would you say this is a fiduciary duty?
Of course,
this is a removal of conflict.
The board is prevented from voting because board is acting in a fiduciary capacity for somebody else.
You could have
shareholder is supposed to act in the best interest.
So he should be allowed to cast a vote in his favor.
In his favor.
With proper disclosure.
And they tried it in England in 1985 in Companies Act, but they didn't succeed, so they brought it back in 2006 Act that the majority can vote.
Again, this is behind us, so let's not debate it as in good or bad, but I think this is what I think from an impact perspective is going to be the single biggest implication for controlling shareholders.
I think from the way I see this is if you already have a provision which says if something is on an arm's length and in the ordinary course of business as determined by the audit committee you don't have to go to the shareholders. And I think therefore this is seeking to as an anti-abuse provision. If something is not arm's length and not in the ordinary course of business, I think legal points have been well made. But what this will do in my mind is, make sure that transactions with related parties go through the arm's length and the ordinary course of business assessment, which is with the audit committee.
Right.
And I don't think that's necessarily a bad thing, in terms of...
One negative fallout could be green mail by small shareholders. I mean, that is going to happen.
No proxy advisory firms.
Yeah, I think it sort of goes as a package.
I find it hard to difficult. I find it hard to actually challenge this provision. Conceptually, to say that somebody who is actually conflicted should not vote in a resolution is a right provision.
So you're in my corner.
Yeah, I know. I do.
I only one corner. On this point, this is the only corner.
Yeah, but I think what I find it hard is the point that you last mentioned, which is actually, is there going to be a green mailing issue? Is there going to be I'll give you an example.
Okay.
Delisting provision. Delisting provision in India is,
Reverse book building.
Yeah, reverse book building, delisting through reverse book building. I would argue has been reasonably, sort of misused by the minority shareholders against many, for example, international companies,
But look, I mean, there was a time when a single shareholder could hold up a scheme for months. Now they've gone the other extreme and said, look, if you don't own 10%, you can't make an objection at all in the scheme. So I'm not sure that,
That's only one single provision which has gone against the minority shareholders. I think the 10% threshold is pretty high.
And I think it's gone incorrectly against them.
Very high.
Who is 10%? Even a mutual fund or an institutional investor would find it difficult then to object to a scheme.
I don't know how the tribunal will deal with it in the past. We have seen the experiences. Yeah.
So we're pretty much at the end of our time. There are several other issues to talk about. I think CSR is a whole new concept in this act. We'll probably touch upon it in future episodes. Mr. Vasani has already touched upon the rules and the overreach, so to speak. The impact on private companies. I mean, that's the subject matter of another half-hour discussion because they've been brought into this act, and I think some of you have already referred to that in some way. Jurisprudence, the old act, all the case law that you have, what happens to the concepts in the new act, how do you work through that?
No, I think there's some guidance available in the sense that it's what they call, if you see the preamble of the act, it's a consolidating and amending act, and there are Supreme Court judgments to suggest that when it's a consolidating and amending act, unless the provisions are identical, the old jurisprudence does not hold valid. The problem I have is some of the landmark judgments of the Supreme Court, whether it was on that Mihir Mafatlal versus Mafatlal Industries, that in a merger scheme, the court is only having supervisory jurisdiction and not an appellate jurisdiction, whether it will hold valid for NCLT because the provisions are not parimetry, they are significantly different. Okay. So that is the worry. See, this company is at one area where they could have done it, that some of the important principles of law which Supreme Court laid down in some of the landmark judgments have not been codified. Whenever you are revising a statute, normally you do that. That has not been done. So many, like Needle Industries judgment on Section 81 rights issue, not codified. So many of these things will come to haunt us. Only time will tell how the courts will interpret it. But the old judgments, unless they are absolutely identical provisions, will not be helpful to us under the new.
All right, gentlemen. On that note, thank you to all four of you for joining us on this very first episode of this brand new series. Next week on Companies Act, we'll be discussing chapters 2, 7, and 13.
Companies Act, a special presentation by The Firm.